Good afternoon. Thank you for attending our town hall meeting on the joint Chicago Bar Association, Chicago Bar Foundation task force report on the sustainable practice of law and innovation. Now that I've gotten the hard part out of the way, I'll introduce myself. I'm Mary Ann Mason. I'm a co-chair of the task force. I'm also the secretary of the Chicago Bar Foundation. I've been on the board for many years. My co-chair is here this afternoon, Lynn Grayson. Lynn is the first vice president of the Chicago Bar Association and a partner at the firm of Nyman Franzetti. Also with us today, but declining to appear in person, is the CBF Executive Director, Bob Glaves. You'll notice that his picture, he's got on a nice blue sport coat and oh, there he is, yes. Okay, you can unmute yourself, Bob, since I'm gonna give you some grief.
Okay, thank you, you got it.
Bob decided not to dress up today. He's got his Irish Fest t-shirt on. Well, actually for him, that probably is dressing up. Because usually he would be in a tie-dye Grateful Dead t-shirt. So, and last but absolutely not least, Jess Bednars is the Director of Innovation for the Chicago Bar Foundation. Jess has been invaluable in this entire process that we are coming to the end of. So again, thank you all for attending. We started this process 10 months ago. Last fall when we started, we thought the problems that the task force had undertaken to address were urgent. We had no idea how much more urgent they would become starting this spring. With the onset of the pandemic and the widespread social unrest following the murder of George Floyd, the frailty of our judicial system and our means of delivering justice in Illinois and across the country became apparent. The task force at that point pivoted immediately to this platform. The work was uninterrupted. The committees continued to meet. We met the really aggressive schedule that we set for ourselves last fall. We had planned to have the report out for public comment in August. Here we are. And we plan to submit the final version of the report after we consider all of the written and oral feedback that we get to the Illinois Supreme Court this September so that they can have it on their November calendar. I see that all of you have muted yourselves, so you're familiar with that function. If you have signed up to speak, I will call on you individually in the order in which you signed up. Please remember to unmute yourself when you do that. When we originally put this out for a public hearing, we had people sign up for 5-minute segments. We're not going to stand on ceremony this afternoon. If you go over, there won't be a red light. Nobody's going to tell you to sit down. By the same token, if anyone who has signed up as an attendee and is moved to speak during this hearing, we're not going to stand on ceremony for that either. If you'd like to say something, just either raise your hand by clicking on participants, and then there's a little raise your hand icon, we'll see that, or physically raise your hand and we'll see you. There are not that many of us. So again, we're really happy that you're here. We are recording this meeting so that we have a record of both the oral comments and the written comments, which will be available on the Chicago Bar Foundation website. I would like to remind you, if you haven't, the written comment period goes through this Friday. And again, we're not going to stand on ceremony. If a few comments come in late, they'll be considered. But we encourage you, to the extent that you personally or people that you know who are interested in these issues, would like to comment on any or all of our recommendations, whether you agree or disagree with them, we'd really like to hear from you. So unless there are any questions, I think our first speaker is John Shikoda. John, could you unmute yourself? And
thank you, Justice Mason. And I want to thank you and Lynn Grayson and Trish Rich, Bob Glaves and his team, Jane Reardon, Mark Palmer, and their team for all of your efforts. I know you have put a substantial amount of work into this, and I want you to know that I'm very grateful for all that you have done for our profession. And I believe that this is a very important issue that needs to be dealt with. I will tell you that originally I questioned a number of the issues that were contained, that were being spoken about. But as I have gotten further into this and as I have studied it, I am in full support of this recommendation to the Illinois Supreme Court. I think the time has come for our legal profession to make some substantial changes as it relates to providing legal services to those very much in need, and that is the middle income folks, which have seemed to be left out of the equation. You have obviously businesses and business owners that have the ability and the means to engage counsel. We've also done a very, very good job, I think, with lower income folks in terms of public interest law. But what's missing in the marketplace, as I see, and I believe there's a lot missing in the marketplace for the middle income and the middle class. And I think the recommendations that the task force is recommending to the Illinois Supreme Court, especially in the area of consumer law, in the area of those that just don't know how to find legal services, and for the lawyers that practice in those areas that are having a difficult time. These are very important institutional changes that will benefit our profession. You know, my mentor in the practice of law, Richard Culver, who is now deceased, who introduced me to the Chicago Bar Association almost 35 years ago, always said that this is a life of service. And I have always believed in that. And to serve, you have to have the ability to reach out to those that need your services. And I think for those in the middle, it's been quite a challenge. And the numbers and the research that I've reviewed very carefully tells me that it is indeed time for us to change some of our rules that are obviously, I believe, archaic. I also believe that we will do whatever we can to maintain the ethical responsibilities of being a lawyer and the practice of law, which are of utmost importance to me. But I think the time has come, and I think it's a great thing that the leadership of the CBA and the CBF are coming together, and I would hope that everyone would support these very important suggested changes to the current rules to provide and to benefit not only lawyers in our profession, but also the public at large. So I'm in full support. Whatever I can do to assist you in the committee, I'm happy to do so.
thank you so much. Our next speaker is Michael Holberg. And Michael, maybe you can tell us what your affiliation is and give us your feedback.
Hi, thank you. As I said, my name is Michael Holberg. I'm a manager at ILES, the Institute for the Advancement of the American Legal System at the University of Denver. So that's who I am with. And I'll say, as this task force has noted in its report, most legal consumers don't recognize that they have a legal problem. And when they do, they know that when they do know their problem's legal in nature, they don't really know where to go, how to find affordable legal help. I would go even a step further and say that most don't know where to find affordable legal help because it usually doesn't exist for a lot of them. And I'm not just talking about the extremely poor, I'm talking about, a large percentage of our population, as was just said, the middle class. And I think this is important to highlight because there's a real harm that is occurring when people don't have access to legal help. And the current regulations right now in many states aren't offering these people any protections. One of the largest barriers in keeping legal help from being accessible is Rule 5.4. I and ILS applaud this task force for the changes that they're recommending to this rule. But we also feel like this task force can go further to make a real impact. One way to go further is broadening recommendation to, in the report, beyond just technology providers, and instead allowing all non-lawyer owned entities, including non-lawyer subject matter experts, to be able to apply to become authorized providers of legal products or services. Rule 5.4 is often talked about as existing to preserve lawyers' independent judgment, but it does very little to offer such protection. Many other rules already protect a lawyer's independence in exercising professional judgment on a client's behalf and freedom from control of others, which is a bedrock of any attorney's ethical obligations. Instead, I'd say Rule 5.4 principally exists to constrain business practices. Most of the rules provisions are not directed toward ethical behavior at all, but instead are economic rules that direct how lawyers are allowed to structure their business with other lawyers and allied professionals. Last, in regard to amending regulations proposed, we believe that the less complex these regulations can be, the better, because complex regulations strangle innovation. The default should be simplicity and flexibility unless more regulation is justified by evidence. ILS has not identified any evidence that sharing legal fees with others, allowing others to have a financial interest in law firms, or allowing lawyers to form partnerships with anyone other than a lawyer if any of that partnership's activities consist of the practice of law, inherently compromise the independent judgment of lawyers, and certainly not in any way that requires their categorical prohibition. And when the rules were originally drafted, there was no evidence that the corporations then supplying lawyers to clients were even harming the public in the first place. We're in a time right now where people need legal help more than ever, and the absence of that help is not only a nuisance, but is detrimental to their lives. I and ILS commend the leadership of this task force, the leadership that you have shown with the proposals that you've put before us. But we do ask to go a step further and broaden the recommendations to allow greater flexibility in the practice of law, which has the potential to greatly increase access to justice, something that should be a fundamental right and not just a privilege to those who can afford it. Thank you very much for the opportunity to speak, for all the work that you've done in putting all of this together, and for the leadership that you all have shown. Thank you.
Thanks so much for your comments, Mr. Holberg. I should clarify for anyone viewing this video, as Mr. Holberg noted, we have not recommended that Rule 5.4 be amended to eliminate the prohibition on the ownership of law firms by entities or individuals other than lawyers. That is an issue that we have recommended that the Illinois Supreme Court study further. Thanks very much for your comments. Our next speaker is Tricia Rich, partner at the firm of Holland and Knight. Ms. Rich.
Sure. If it's okay, I would like to defer to the end, if that's all right.
We had 3 people sign up.
Oh, okay. I am at the end. All right. Perfect. Okay, thank you. Yeah, so I didn't actually prepare anything to say today, so I will keep my comments brief. I know a lot of you on the call. For those of you that I don't know, I am an attorney in private practice here in Chicago. I work at Holland and Knight. My practice consists of, I'm a commercial litigator, but more relevant for our purposes here today, I am, ironically, I'm an expert in legal ethics issues, which the joke I always make is if anybody knows anything about it, you know that I'm not allowed ethically to even say that. So it is an exact fit for what we're talking about today, which is the regulation difficulties that we have right now. The fact that I can't say to you guys that I am an expert in the very thing that we're talking about is one of the problems with the rules that we're talking about, right? Is that they over-regulate our profession in a way that has become cumbersome, but more often has just not kept up with the way that we practice law. And so I said I'll keep my comments brief because frankly, I was on this task force and I spent a lot of time on these issues over the last few months with some of the other people on the call. I wanted to sit in today in case there were any other issues that came up that I felt like would be helpful to have my perspective on. One of the other things that I am involved with is the Association of Professional Responsibility Lawyers, which is the national group for legal ethicists and people that do what I do. I'm a board member on that group, and I will tell you one of the things that I'm really proud of right now, being a Chicago lawyer, is the CBA and the CBF's initiative on doing this, being the first the first non-state bar, so voluntary bar association to take this on, and being a part of that has been, something I'm really proud of. But the reason I bring up April is to say, the people I work with all over the country that do what I do are watching this very carefully and watching it very closely. Like we're watching Utah, we're watching Arizona, we're watching California, and now we're watching Illinois. And I think that Illinois, we have this like very particular moment in time where we have an opportunity to be a real leader in the way that we practice law going forward. I'm proud to have been a part of those efforts, but I think it's a really important thing that our Supreme Court recognizes that we can forge this path in a way that makes sense. Mr. Holberg, we haven't met before, but I really appreciated your comments because I too think there are places in this report where we could have gone farther. But I have reminded myself many times throughout this process that we cannot let the perfect get in the way of the good, and that any step forward is a good step forward. And I think what we've come up with is a very reasonable set of proposals that will begin making some really good changes while not being so extraordinarily out there that it's scary for people, frankly. So I am glad to be on this call and serve as a resource if anybody has any questions. But I really just wanted to sort of hear what other people had to say about this, and that's why I'm here today.
Thanks so much. We did definitely try not to be out there. Could I just throw it out to anyone else on the call today? Is there anybody else who would like to be heard? Hearing none. I want to thank you all again for attending. This was a 51-member task force with a 17-member National Advisory Council. When we started 10 months ago, everything was on the table. Nothing was off limits. The product of the last 10 months landed in your email boxes about a month ago. And I can't tell you how much we appreciate your taking the time to look at the recommendations that we've made, to consider them, and to give us your feedback. We look forward to continuing to work with the various organizations across the country, and more specifically with our Supreme Court, as they consider the proposals that we will submit to them in final form in September. Again, if you are moved to submit any comments in writing, please do so. If you go to the Chicago Bar Foundation's website at chicagobarfoundation.org, there's a link to the report and to the written feedback form. We would love to hear from you. Unless there's anything else we need to take up, I'm going to thank you for coming, and we'll conclude our public hearing. Thanks so much.
Thank you all.
Thank you so much.
Thank you.